On the slopes of Diamond Head, this is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
This is Ben Carroll. Welcome to the Legal Environment of Business, BLAW200. Well, on our last visit, we looked at agency, talked a little bit about employment law, and today we're going to move directly into employment law, so that should be something familiar to all of us. But we will start with our review of the agency area. So, what is the nature of agency, and how do agency relationships arise? Well, agency relationship is a relationship where you are acting for someone, so you're a representative. And the normal way of doing this, of course, is to agree that somebody will be your representative. It is a fiduciary relationship, and that means that the agent is going to be acting on behalf of the principal, and the principal's interest will be paramount. So the agent will put the principal's interest first. So how does it develop? Well, as we said, the easy way is that you come to an agreement with someone, but it's possible for it to rise in other circumstances. For example, if an agent or someone acts for you and then after the fact you give them authority or say that what they did was okay, this is called agency by ratification. So you can ratify an act afterwards. And the example we used is if someone is hired as your agent to show your house, they notice something's going on, flood, fire, or something, and they take care of that even though you didn't specifically authorize them to do that for you. You're happy with that, and after the fact you say, you did have my authority to do that. The other possible ways it can arise are by estoppel, and that means that you have caused innocent third parties, other people, to think someone is your agent. So you may refer to them as my representative, or they always come around with you on your customer calls, and you lead someone else to think that that's your agent. And in that circumstance, if the third parties act like they're your agent, if they rely on you, your representations that that's your agent, then you will be estopped or stopped from saying that person's your agent. And then finally, we talked about operation of law. So in some instances, the nature of the relationship includes agency, and that can be certain familial relationships or employer-employee. Okay, so what are some of an agent's duties, and what are some of a principal's duties? Well, we had a couple of long laundry lists, but they're kind of the obvious sorts of things. So the agent is responsible for doing what the principal tells them to do. So there's a duty to follow instructions. There's a duty to be loyal to the principal. There's a duty to give the principal information about the monies you have or the information you receive as an agent, because you're doing the day-to-day things on behalf of the principal, and they need to know what it is you're doing, because, of course, they can also incur liability for the principal. So principal's duties, again, some of these are fairly obvious. Principal needs to pay the agent, compensate the agent, reimburse the agent for any expenses that are incurred, needs to indemnify the agent if the agent somehow incurs legal difficulties while they're doing an authorized act. So those are some of the basic duties between principal and agent. What's the difference between actual and apparent authority, and which type of authority is concerned with third parties? Well, actual authority can be express or implied, so that's the authority that is either directly given to the agent or is clear from the circumstances. Apparent authority comes from the word appear, so that's where it appears that the agent has authority, and that, of course, is the type of authority that's involved when we talk about agency by estoppel. So we have made it appear that this person is our agent. When is the principal liable for the agent's action, and when is the agent liable? Well, in most instances, the agent's going to be liable for their own activities. In certain limited instances with a contract, then the principal would be liable and not the agent. But certainly in the tort area, the agent is going to be liable for what they do, and the principal will be liable if it's found that respondeat superior applies. In other words, circumstances where the principal should cover the agent's actions. And this is when the agent is acting in the course and scope of their agency. So they're doing what they're supposed to be doing. They're doing something meant to be within the agency. So these are examples we used. Somebody that's hired to drive your vehicle. And so if they get in an automobile accident, then they would be responsible. And so would you if they're in the course and scope. And we talked about the criteria we would look at to see whether or not respondeat superior would apply. What's the difference between an employee and an independent contractor, and how's the status determined? Well, we said the two major areas of agency are independent contractor and employee, and the key difference here is the control over the details of the work. So when we hire an independent contractor, in many instances we're hiring somebody for their expertise. We're hiring them because they know how to do something that we need, and we think that they're professional in that area. So this can often be a one-shot sort of deal, like sell my house, or it can be more longer term. Somebody will regularly come in and work for you. But what makes them an independent contractor, for the most part, is you don't tell them how to do their work. On the other hand, an employee, you would be expected to train, tell them how you do things in your office, that sort of thing. And you would tell them when to show up, exactly how to do things, the methods that they would use to do their job. So that's a major difference. Another area that's important, obviously, is the liability. So you are liable for your employees for the most part because you are telling them how to do things, whereas an independent contractor, for the most part, you're not, because you're not telling them how to do things. And then the obvious area is employees are entitled to a number of benefits, and there's some responsibilities you have for employees, legal responsibilities. And we'll be talking more about those today, the kinds of benefits that are required. You do not have to pay those types of things, taxes and benefits, for an independent contractor. So a contractor would need to have their own insurance, their own arrangements for if they get injured, that sort of thing. So you would be paying them, essentially paying an independent contractor, oftentimes a set fee, and you would be buying the result. And how that gets accomplished isn't so much your concern. Again, you're hiring them for that purpose. Again, there's a long list of criteria that the IRS uses, and that's been posted on the website. So there are a number, maybe 20 different criteria, but the three we've talked about are kind of the main concerns. What are some of the ways that the agency relationship can be terminated? This, again, harkened back to when we were talking about ending a contract, because in most instances this is agency by agreement. So we're talking about the impossibility of performance. You can't sell a house if the house has been destroyed. We've talked about a number of ways that the principal and agent themselves can end the relationship, from the obvious that the purpose of the agency has been fulfilled, or the set time limit they were going to represent you has finished, or one or the other of you decides to change the relationship. Okay, well, we're going to get into the employment area today, and all of you have jobs, hopefully, so this will be an area of some familiarity to you. So we'll talk about the laws that apply to the employment relationship, some rights and responsibilities. We'll talk about the benefits and how the law takes care of employees and this relationship. We'll talk about some specific issues that come up in the employment relationship. And then finally, we'll talk about unions, labor, and collective bargaining. Okay, so first concept we want to look at is employment at will. And it means that the employment relationship, there's no obligation to have it to continue. And under common law, at least, they could terminate the relationship for any reason. So you're only my employee as long as I want you. I don't have to give you a reason to end the employment, and I can have any kind of reason. So it can be a a reason that appears silly or of no reason need be given. Now, this is, again, the common law, and it has been modified substantially by the law. As we often see, common law sometimes can be a little harsh, and this has been modified considerably over time. So, what are some of the exceptions to at will? Well, there are a lot of statutory and public policy restraints, so we have decided that these are not appropriate reasons to allow a person to be fired. There's going to be some contractual terms and conditions. So employment at will occurs when somebody hires you, but there may also be an employment contract. So there may be representations and provisions made to you contractually that would modify this. So we will only fire you for good cause or something of that nature. There's also the possibility of implied contract. So just as there can be an express written agreement or oral agreement, there can also be a contract implied. And we know that the law implies agreements and conditions when it thinks it's necessary to be fair. So that can occur also. And then finally, there are just some usual common law conditions about firing people. So you could end up, an employer could do things that are tortious, that would constitute tort in wrongful termination, intentional infliction of emotional distress, defamation. Those other things could also apply to a firing in the employment. Okay, so looking at these a little more closely, statute and public policy. So we will be talking about this next time, but the law prevents discrimination. So if we're going to hire or fire based on a protected category, in other words, we're not going to hire anybody or we're going to fire people of a particular race, religion, gender, etc., then there are going to be some laws that prevent this, some civil rights laws. So we are not at will in the sense that we can hire and fire for those reasons. Also, the government employees generally have at least a right to some basic due process. So if you work for state, federal, local government, generally there will need to be some sort of good cause or at least going through a process before you can be fired. Okay, there's also other types of public policy where the state, the government, society has decided that these are public policy concerns, and so we want people to be able to fulfill their civic duties, and so if they do and they're fired for that reason, then we're going to protect that. So if your employer asks you to do something illegal and you refuse, they may be unhappy with you, but if they fire you for not doing an illegal act, then you're going to be protected. If you exercise a statutory right or duty and you are fired for doing your public service, then you may be protected as well. So this might include if they don't give you any time off to vote, or there is also protection if you're in the National Guard and called up and come back, whether your job's still available. So there are protections for things that society and the public feels are a citizen's duty, and if the employer doesn't recognize that, society will, and so they'll protect those. And finally, we have what we call a whistleblower. So, what's a whistleblower? Well, whistleblower is somebody who reports or announces that the employer has done something wrong, is breaking the law, dumping illegally against environmental regulations, doing some kind of fraud or something, and they report them to the government authorities. So you can imagine that this is going to make them unpopular with the employer, but the society wants to encourage that illegal acts be reported and taken care of, so they are going to attempt to protect the whistleblower. So whistleblowing, actually where the term came from, it actually came from England, where the policemen, the bobbies, did not carry weapons, so when they noticed something was a problem, they would simply blow the whistle to have other people come and assist them take care of the illegal act. Okay. Now, unfortunately, we try and protect whistleblowers, but there are ways of blacklisting them and making life miserable. So we'll talk a little more when we talk about corporate responsibilities. There are now ways to report people anonymously so that the person reporting doesn't suffer any consequences, because the law, of course, can't completely protect you in those instances. Okay, another whole area is contractual provisions that protect you as an employee. So the contract itself may provide for firing only for good cause. It may indicate certain other things that would be the cause for firing, theft, that sort of thing. And there may be a collective bargaining agreement. So there may be an agreement that's not your individual contract, but that you're part of, so a contract with a union and the employer that also provides you with certain rights and protections. And then finally, there's maybe the question of whether your employee handbook or your manual gives you some rights. So there are many instances where you will receive an employee manual. It may simply be a Xerox sheet, but in any case, there's something in writing that is given to you and says these are your rights and responsibilities in this job. So it's not necessarily an employment contract, but there's some questions about how that relates to your employment. Okay. Now, this is where we get into implied contract. So if the employer makes some representations to you, then it may be that they would be held to have made promises, and the court will look strongly at that. So if they tell you that your employment's for a particular time and that sort of thing. And another whole area is the idea of the employee manual, whether or not these are representations that they will be held to. Now, they're aware of, employers are obviously aware of the possibility that these representations they will be held to. So, for example, the employer's counsel will tell employers exactly how to handle this so that they are not making an employment contract in their materials. But even so, no matter what they put in the manual, it's possible that the court will find under the circumstances that there's an implied contract. Okay, so this is some provisions in the employment manual, in the handbook. And you can see here in bold, this handbook is not a contract of employment or a promise of continued employment. So that's printed right here. It's the only bold thing on the page, and it's saying, we're giving you all this written material, but this is not part of your contract. And there are several places here, probably 4 or 5 places where we keep using the term at will. So it indicates that you are in employment at will. Successful completion of the orientation period does not guarantee continued employment or alter the employment, at will employment in any way. And that's repeated numerous times in the handbook. Okay. Again, at the end, except for an arbitration agreement here, no provisions in this handbook constitute a contract. They're mere guidelines. You should not rely upon them. They do not promise specific treatment in situations. Nothing shall be contractual, and this is all non-binding. So again, repeated all the way through the handbook, indicating this is at will. We're not modifying that in any way. And then finally, they're going to have us sign this. So this is a receipt of the handbook. So I acknowledge I've received this. I'm an at-will employee. Policies contained in the handbook do not constitute implied or express contract. Don't expect continued employment. Doesn't alter the at-will employment relationship in any way. No promises of specific treatment. Does not create an atmosphere of job security. My employment will be undetermined duration with no fixed term. So again, sometimes seems like when we read this that half the book is telling us that the book doesn't apply or the book's not a contract. But again, as we talked about, it's entirely possible that the court's going to look at this and say, if the employee has to follow it, so does the employer. So there may be instances. I have to say, though, that they've repeated it all virtually every page here, so this is probably as good as it gets for the employer to try and keep this out of being a contract, and certainly with respect to a continued length of employment. So if nothing else, all of these provisions do indicate we did not make any promises about duration. It's clear we talk about that several times. Okay. Now again, when they say at will, we keep saying at will, but the truth is, It's only at will when it doesn't bump up against one of the statutory or public policy provisions. And at that point, all the talk about at will doesn't make any difference, because if you're violating one of the statutes that specifically governs the employer-employee relationship, at will's out the window. Now, there are, again, the common law remedies we talked about, regardless, and that's if you're fired in a certain way, wrongful termination, that sort of thing, then there can be some remedies for that. Okay, so what are the state and federal laws that we are interested in? So obviously the government is interested in this relationship because of full employment and fairness, etc. So a number of things that we're trying to do is to provide a safety net for unemployed and disadvantaged workers. So we'll talk about some of the laws that apply to that, minimum wage, etc. Trying to prevent exploitation. So we'll look at discrimination next time, but we'll also today look at overtime pay, child labor, that sort of thing. And then finally, we'll look at protecting health and safety. So we talked about one of the principles obligations was to have a safe place to work, and that's even clearer when we're talking about employees. And then finally, the long-time security of our population is of interest, so there's certain interests the government maintains with respect to retirement and medical. So this is the reason the government is involved in our employment relationship and why we've got a lot of changes to what was the common law at-will doctrine. Okay, almost all states will have their own system to protect the employer as well as the federal laws that we'll talk about. So for the main, we'll talk about federal law, and state law have counterparts to that. So the federal law is generally going to be covering anything that involves interstate commerce, and it's going to set kind of the minimum floor. So if they have a federal minimum wage, that's going to have to apply to all states. The states can't have less. However, the states can provide more benefit. So in most of these instances, when we look at what the federal law provides, that's the minimum or the floor, and the state can provide additional benefits, more benefits, or take better care of or more protection for the employees. Okay, so just a quick look, and there are some charts that lay this out in detail for you on the website, but generally when we look at the federal side, you can see in many instances there's a state counterpart. So for example, our Fair Labor Standards Act, on the other side is the State Wage and Hour. We have the Occupational Safety Health Act, OSHA, and we have both state and federal OSHA. In terms of the workers' compensation, the federal has that for federal workers, Federal Employee Compensation Act, and the Longshoremen Harbor Workers' Compensation Act, and state has workers' comp. Have a lot of labor laws we'll look at, and have some state laws as well called Employment Relations Act. And again, the state can protect more. We'll be looking at that. Now, the Social Security Act doesn't really have a state counterpart, and then there's some areas that are given to the states, such as unemployment and the prepaid health care we have in Hawaii. So there's a lot of correlation between the federal and state acts, and just remember that when the federal law is there, that provides our minimum, and the state can provide more for its citizens. Okay, so we'll start looking at the laws individually. The Fair Labor Standards Act is what we call wage and hour, and this is what all employees are interested in. So it's going to tell you about the minimum wage. It's going to talk about the hours of work and which employees will get overtime. And then finally it'll talk about child labor. Okay. Now, child labor applies to certain kinds of jobs that you can do at certain ages. So what we consider to be hazardous jobs, you would have to be of age. A minor could not do that. Okay, there are going to be certain jobs involving interstate commerce, and you cannot do that under a certain age. But of course, there's some jobs that are not going to be really covered at all. So we're not going to be looking at who mows the lawn and who does babysitting, that sort of thing. But if you're going to go out and work in the economy, then these laws may apply to you. Okay, now in the safety and health area, Both state and federal are called OSHA, Occupational Safety and Health. And this concerns setting up standards for various kinds of industries. And the book of rules here is extremely thick. So they're going to be looking at the cleanliness in restaurants. They're going to be looking at anything that has to do with health and safety. So they're going to conduct inspections of the workplace. They're going to investigate employee complaints, that sort of thing. And almost any business that ever has received an OSHA visit is probably going to have some violations, because there's going to be some place where a mess wasn't cleaned up, or there's going to be evidence that a cockroach or a rat has walked along your area. So there'll be something wrong there. But most of these are minor, unless somebody's actually been injured. So if there is an injury that causes death or hospitalizes a number of employees, then you need to report that to OSHA. And you have to do it fairly quickly, and you have to do it fairly completely. If you do not, in these instances where safety has been violated, then there can be substantial fines and penalties. So if you have a construction death or something of that type, OSHA will immediately get involved. Okay, now workers' compensation, a number of folks are probably familiar with, and this involves when you're injured at work. So if you're injured on the job, then you are going to be provided with some benefits. And this is a public policy decision to take these kinds of cases out of the legal system, so to speak. So if under common law, if you were injured, you would have the right to sue whoever injured you, if it was your employer, fellow employees, etc. Problem being that when a single employee would sue an employer, the likelihood of success is pretty limited, particularly if all your witnesses also worked for the employer who's going to testify against the person paying them. So this was a public policy decision to set up a compensation scheme, a system that takes these cases out of the regular tort system. And what the trade-off is that you are trading your right to sue for some, in essence, guaranteed benefits. So if workers' compensation applies, that's the sole remedy you have. Now, this involves accidental injuries, and they have to apply in the course and scope. So remember we talked about course and scope is now a familiar term to us. So if you are injured while doing your job and it's accidental, then you would be covered by workers' comp. And if you're in that, then that's going to be your exclusive remedy. So you get essentially in workers' comp, you will get what we call special damages. And you remember that means the actual damages to compensate you for loss of limbs or use or whatever. Okay. Now, sometimes if somebody's injured at work, they would have remedies outside that. So remember we said workers' comp is for accidental injuries. If it's intentional, then you might be able to bring a suit against the person that intended your injury. Or if it's done by people not covered by comp, like suppliers or customers or other people, intentional tort. So that might take it out of the work comp system. But if you're in the comp system, if you are injured by accident in course and scope, then you're covered, and that's your only remedy. Okay, and we talked a little bit about income security. So this is where a lot of this obviously arose out of the Great Depression, many years ago, where people were destitute, no job, etc. And so that's when Social Security was put into place. So Social Security will provide both for retirement. It also provides for disability. We'll talk more about that. It also provides medical, so Medicare and Medicaid. And in addition, there is a regulation called COBRA, and you won't know what COBRA means. Everybody calls it COBRA. It's the Combined Omnibus Budget Reconciliation Act. Who cares? But COBRA essentially means that when you have a medical plan provided by your employer and you leave your job, you can continue that coverage at your own expense for 18 months. So it allows that when you have employer-provided medical care and you leave, you're not going to be dropped from the plan. And of course, this is important because if someone has a condition, what we call a pre-existing condition, and they get dropped, they would not be able to get new insurance even if they paid for it. So this allows a period between jobs that you can maintain your coverage, again, at your own expense, but you do have the right to be part of the plan. Now, remember we said that the state also provides additional types of benefits in this area, so that would be your unemployment benefits and the comp we just discussed. With respect to what the company may provide, when you retire, you would get your Social Security benefits, but of course that's not going to be much to live on. It used to be that most companies, particularly the large companies, provided pension benefits to their employees. So at one point we had to talk about a variety of different pension plans that your employer might provide. Defined contribution, defined benefit. There's quite a bit of planning involved with that. Unfortunately now, many companies provide little or no pension benefits. But if you are part of a company that has a pension plan, then it will be subject to what we call ERISA, which is the Employee Retirement Income Security Act. And that will regulate how that plan works. And actually there's a guarantee, government guarantee, that those benefits will be available to you. But again, nowadays, if you work for the government or, for example, for the military, you may have retirement benefits, but many companies no longer provide retirement benefits. So the final line of defense for retirement, at least, is what you save yourself. So you're probably familiar with individual retirement accounts or 401k plans. For the most part, this is your money. And what does the government do for you? Well, they give you a tax break. So the taxing of your IRAs is beneficial to you. Generally, you either pay up front or you don't pay now. You pay when you retire and your income is lower, so your tax level is lower. So that's what they're doing for you there, is giving you a tax benefit. Okay, there's a whole slew of other employee rights, and there's more material for you on the website on this. So there's the Family Medical Leave Act, and this provides employees with time off to take care of family or medical business. And then there's also some responsibilities you have as an employee, and this has to do with trade secrets, non-competition clauses, that sort of thing. And again, more information on that on the website. Okay, so there's a lot, when we talk about all these laws, there's a lot of enforcement. We'll talk a little bit more about administrative law and departments and agencies down the road, but you can see an awful lot of departments and agencies are involved here. So if you have wage and hour issues, Family Medical Leave Act, you would go to the Department of Labor. If you have safety and health issues, you would go to the Occupational Safe and Healthy Administration. If you have retirement issues, it would be Social Security, labor, which we'll talk about shortly, National Labor Relations Board. Next time we'll talk about discrimination. You would go to the Equal Employment Opportunities Commission, and then, of course, there are state agencies operating in these areas as well. So a lot of moving parts to the protections provided to employees. Okay, well, let's get into labor law. So when we talk about labor, generally we're talking about the workers in unions. So we're talking about collective bargaining. We're talking about a history we have here. And there is an extensive history in Hawaii, and again, more materials on that for you on the website. Okay, so the major laws here are in the federal area. We do have state equivalent, but this is a federal area. And the reason we have a lot of federal laws is because this used to be a very violent area of the law. So when labor unions first developed, people were being killed. And so there's a lot of federal law here. Take a quick look at them. The Norris-LaGuardia Act, also called the Anti-Injunction Act. And you can see these started back about the time Social Security was starting, so this is back in the 1930s. We have the National Labor Relations Act, also called the Wagner Act. Had the Labor Management Relations Act, also called Taft-Hartley, and the Disclosure Act, called Landon-Griffith. So You'll see a lot of times we refer to these by the names, the popular name. I think the one that not so much is the National Labor Relations Act. We often refer to that rather than Wagner. But you're going to see this both ways. But I think, as indicated, for the most part, we're going to use the names of generally the people that brought these acts into Congress. So what do they provide? Well, Norris-LaGuardia Act restricts the use of injunctions against peaceful labor disputes. It outlaws yellow dog contracts, and it prohibits restraining strikes and picketing. So this is really the first time that there's a recognition that peaceful labor disputes are not violating the law. So initially when employees would have strikes or whatever, they were enjoined. So they were the companies would use the injunction as a device to stop any of this kind of activity. For example, they were claiming that this is violating public peace, etc. But this act said that if they are gathering peacefully to protest, then you cannot use the injunction. So it restricted the use of federal injunctions in this area. Now, yellow dog contracts, this was a description that the union members or the labor people would give to contracts that said, employment contract, if I work for this company, I will never join a union. Okay, so I will stay out of the union. And it was found this was not proper also. Okay, then we really got serious about recognizing that people had a right to bargain collectively with the NLRA or Wagner Act. So this specifically recognizes the right of workers to band together, to collectively get together in a union and bargain with the employer. So it covers interstate commerce. There's some exceptions for airlines, certain domestic workers, railroad. So there's a few exceptions, but it pretty much covers most employment. And it established the National Labor Relations Board, and they will enforce labor law both with respect to what we call unfair labor practices and also union elections. So again, this is kind of the seminal law, the primary law that recognized the right to bargain collectively. And if you think about it, if you're trying to negotiate a contract as an individual with your company, you're one of several thousand, you don't have much power. You don't have much bargaining chip. And so it's recognized that when the employees all get together and collectively bargain as one with the employer, that this kind of evens the table. Okay, the NLRA gave a lot of rights to the union members, and then the pendulum kind of swung the other way, and it was felt that the unions were getting too much power, that when they got together they were shutting down industries. This was right after the war where everybody worked together, and now the idea is with the Cold Wars here, we're afraid the unions are being infiltrated by communists, this sort of thing. So it was felt that the power had swung too much to the unions, and so now we need to protect the employers as well. And so whereas the NLRA had talked about unfair labor practices that the employer was prevented from doing, now we're going to do the other side and say there's some unfair practices that the labor unions are prevented from doing as well. So it's an attempt to balance the power, so to speak, in these negotiations. So Taft-Hartley outlawed what we call closed shops, and it allows union shops and agency shops, and we'll talk about those in a minute. That's the requirement that somebody be part of a union in order to work. You recall the Yellow Dog contract said you can't be a member of the union to work. So the unions had come across and said you got to be a member of the union to work. So we're going to strike a balance here. It recognizes the right of an individual worker not to join a union, and it allows right-to-work laws. So many states are what we call right-to-work states, and then you can prevent unions from requiring union membership. And finally, it created the Federal Mediation Conciliation Service, FMCS, and this is a major organization that mediates disputes between involving collective bargaining and between labor and management. So again, we talked about this being a very violent area, and this is an attempt to bring the parties together and to resolve some of these disputes. Okay, the last major act is Landon-Griffin Act, and this is, again, directed more towards the union. So the unions had become powerful. There appeared to be some collaboration between some of the unions in the management, and the people getting left out was felt were the union members. So this is meant to protect the members themselves, to avoid racketeering and corruption in the unions themselves, and give rights back to the individual union members. So it provides procedures for conducting union elections to make sure they're fair and that sort of thing. So it's kind of like a Bill of Rights for union members. So you can see with these different acts what we've done is we've made sure that the balance of power between management and labor is fair, and that the individual union member, although perhaps gaining from the collective bargaining, isn't getting screwed by the union itself that has become very powerful as well. Okay, so talk a little bit about union security, and again, this is part of the evolution. So closed shop is where you had to join a union or you couldn't work at the company. And so this is kind of the counterpart to the yellow dog. So the yellow dog contract where you couldn't be a union member was tossed out, and Taft-Hartley also tossed out the closed shop where you had to be a union member. Okay. Did allow in certain circumstances what we call a union shop and an agency shop. Agency shop essentially means that you will pay the dues even if you don't want to be a union member. So you'll pay most of the dues, not the political part, but the administration part. Okay. Open shop means that this is kind of the right to work, same benefits for everybody. And then membership maintenance is kind of a hybrid there that says that when they first take over, you will stay till the agreement expires. Okay, so you can see there's a full range of this, and again, the closed shop is tossed out just like the yellow dog contract. And the rest of these are available depending on your state. If you're a right-to-work state, then you're open. So what do I mean by collective bargaining? Well, we talked about that. Collective bargaining is simply everybody bargaining as a collective together. So all the employees are represented by the union. And it includes not only the bargaining to get the agreement, and we call the labor management agreements collective bargaining agreements, typically. It also includes all of the disputes and whatever they're after. So there are a lot of grievance procedures. A lot of this is is pretty well put into procedure so that you know how somebody can be fired, et cetera, discipline, progressive discipline. All of this is very well structured when we have a collective bargaining agreement. Okay, so what are the bargaining issues? Well, there's some issues that have to be bargained, and we call those mandatory issues. So that's the basic core of your responsibilities: wages, hours, working conditions. So those have to be bargained if you're in this situation. Then there, on the other side, there are some issues that you can't bargain. So again, we said closed shop is illegal, so you can't bargain about whether or not to have a closed shop. It's illegal. You can't have racially discriminatory matters. We'll talk about that next time. That's illegal. And you can't have a hot cargo clause because that's illegal. So that was a provision that unions used to put in saying, we won't handle goods of a certain from a certain place or a certain type. So all of those are prohibited. So we have things that have to be in your agreement, and you have things that can't be in your agreement. And then we have a whole lot of things that are permissive, so they can be in the agreement or not. So either side can refuse to bargain about these. You can bring them up, but if the other side says, we don't think that should be in there, it is not mandatory. So this could be things like retirees, how exactly you perform the work, that sort of thing. And there are sometimes disputes about whether something is permissive or mandatory that would have to be resolved by NLRB, mediation, etc. Okay, so you can see again, mandatory have to talk about, illegal or prohibited issues, and there's the voluntary issues where you can or cannot. So you can refuse to bargain about those. Okay, there's a requirement of good faith bargaining. This is the duty to meet at reasonable times and to in good faith attempt to bargain. and either side can request that items that are being discussed be put in writing. So both sides have a requirement to bargain in good faith. Bad faith is a little harder. It's not quite so clear, but bad faith is when you are clearly not intending to work toward a result. So unreasonable demands, trying to bypass the union, failing for either side to designate an agent that has any authority. In other words, just going through the motions, delaying tactics, etc. So when collective bargaining is in place, you have a duty to bargain in good faith, and you can be charged with bad faith bargaining. Okay, so what happens when we reach an impasse, when something we're not able to proceed, one side or the other is not bargaining in good faith? What do we do? Well, the remedies we have are based on the power we have, and the power of the union is to strike. In other words, to stop working and to shut down the employer. On the other hand, the employer also has some possibilities, and they can lock out the workers. So they can say during a strike, well, you're locked out and we're going to hire some replacements. So in certain instances, they can say, you're not going to work, fine, we'll get somebody else to work. So this is kind of the balance of power there. Okay, different kinds of strikes. Some of these are legal and some of them are not. So an economic strike, we'll talk about in a minute. That's the usual strike we see, and that's for wage, hours, conditions, the mandatory subjects. Unfair labor practice strike is where there's an allegation that something's being done by the company that violates our agreement or violates the law. These are both legal types of strikes. And then we have a number of possibilities of work stoppage that are illegal. So sympathy strike, also called secondary strike or secondary boycott, and a wildcat strike. We'll look real briefly at what these look like. Okay, economic strike, again, this is over the basic rights and responsibilities. So this is generally the kind of strike if we're trying to get a collective bargaining agreement or the agreement's expired. If this kind of strike occurs, it's the right of the employer to replace the workers. So the employer can use management to do these functions and can hire replacements. And you've heard the rude terms that a replacement worker would be called. Typically, union is going to call them scabs. Unfair labor practice is where that we're protesting that something the employer does violates the law or the agreement. And this might be if we fire someone because of the union activity. So this is a prohibited practice. The union is allowed to hold elections. The union is allowed to attempt to be the representative in a workplace. And so if someone's fired, that's an unfair labor practice. And either the union could go through NLRB, or they could strike on this, or they could do both. But this is a legal strike. If there's an unfair labor practice, then the company may be prevented from replacing those strikers after it's over. Okay. And again, we talked about some unlawful strikes. So this would be unauthorized work stoppage, no basis for that. And secondary or sympathy strike is where one union is having a problem with management and others in solidarity in unity strike their employers to bring economic pressure. So this would be illegal, and these can be prevented by injunction. Okay, so quick summary of labor law. We've got the Norris-LaGuardia Act, which was the Anti-Injunction Act. Got the NLRA Wagner Act, gives us the NLRB, right to organize. This is the critical act. Talks about employer unfair labor practices, sets up the National Labor Relations Board. So this is kind of the major act that sets things up. But then the power over time seemed to move to the union side under this act. So the Taft-Hartley was kind of a reaction to that. Taft-Hartley discussed the kind of the opposite side, the unfair labor practices by the union. It set up ways that if the strikes were damaging national security or emergency, then they could be prohibited. and it allowed people to have right to work. So it said that some states could elect not to allow agency shops. And then Landon Griffin was kind of looking down and taking care of the union member themselves. So it talked about corruption in the unions, member rights, how union elections were held, that sort of thing. So a lot of other amendments and pieces to this. Again, it's an area where it started out violent, so there's a lot of law here to try and make sure this continues to be peaceful and orderly, but those are your four main areas. Okay, so I'd like to talk just a little bit about where unions are going. So you can't read the bottom, but this is Labor Statistics, Department of Labor, and it indicates what's happened over time with the labor union movement. So back in 1945, right after the World War II, there were 36% of the labor force in the United States was unionized. And you can see it's come down to a few years ago, it's down to 12. So it's been reduced by 2/3 the amount of people that are in unions. And you've seen this, a lot of the industries are getting smaller and less unions around. Okay, so which states have the most unions? Well, you probably knew this, but Hawaii is right up there. So Hawaii is number 2 in the amount of workers in labor unions. So New York is number 1, and that's almost entirely because of New York City, but Hawaii is number 2, very heavily unionized. And again, this is part of our history, the plantation system, the land ownership system, the workers brought in to work in these industries, particularly pineapple, sugarcane. And again, there's a lot of Hawaii labor history on the website that you can take a look at. You can see, on the other hand, the Deep South has not got very heavy unionization. Again, these are what we call the right-to-work states, and you can see all of those at the bottom: Louisiana, Texas, Virginia, South Carolina, Georgia, North Carolina are all at the bottom end of number of unions. So it goes from New York with about 25% of the labor force in the union, down to about 4 in North Carolina. The United States is right around 12.5% of the entire United States labor force is involved in a union. Okay, worldwide unionization. You can see United States is kind of in there in the mid, although I guess we're kind of towards the low end as well. So very low in France, 8.3%, all the way up to some of the Scandinavian countries and Northern European countries. It shows Norway at 53% unionized. Okay, so the United States is really kind of on the low end of that worldwide. Okay, well, we have taken a look, and I've realized we've zipped through the labor area. The labor history is quite interesting, and again, there's quite a bit posted on the website on Hawaii labor unions. We have some exercises, and there is some material about our own Hawaii history that you can take a look at. Next time, what we're going to be looking at is we're going to be looking at employment discrimination. So we've hinted at that today. We've talked a little bit about some of the issues that are going to be protected. Again, this is an area where the government is going to protect us from illegal acts. So we'll be looking at employment discrimination, including Civil Rights Act, Americans with Disability Act, and other kinds of discrimination against workers. So this has been Carol. I will see you next time.